Welcome everyone. My name is Richard Shannon. I'm the Executive Officer of the NFF Horticulture Council. Welcome to this first webinar as part of a two-part series that the Horticulture Council is hosting with an aim to build awareness of fair trading practices within the fresh produce sector. And so this first webinar, as you all know, is covering rights and responsibilities under the Horticulture Code of Conduct, including a review of some updated guidance that has been issued last year by the ACCC. The second webinar will be Thursday, 9th of March, also at noon, and that will be covering the rights and responsibilities of supermarkets and their suppliers under the Food and Grocery Code. We are exceptionally pleased to be welcoming our friends at the ACCC, and in particular, ACCC Deputy Chair and Agriculture Commissioner Mick Keogh as our guests to help lead us through both of these webinars and both codes of conduct. In terms of, I guess, the council's objectives here, these codes of conducts are really important for our industry. We do understand that the majority of relationships between growers and their buyers are long-standing and often marked by mutual trust and respect. That said, codes of conduct, regardless of the relationship, still play a really important role in providing both parties an important benchmark of fairness and creating a level playing field for the entire market. And so the council does see it being an important role in raising awareness and understanding of how these codes work over time. And so we're really glad to bring this two-part series to you all, and thanks again to the ACCC and Mick in particular for making themselves available to help lead us through this content. With that, I might hand over to Mick to take us through his presentation, noting that I believe we have made some provision for asking questions at the end of the session today.
Thanks very much, Richard, and thanks for the opportunity to present. I should first do a sound check. Is that coming through okay? Excellent. Yes. Well, as you've indicated in the introduction, the ACCC is the regulator that has a number of roles, and in particular, we look after a number of industry codes in a range of different industries, but in particular in the agriculture sector, we have the Horticulture Code and the Dairy Code, and we also have some responsibility in relation to the Food and Grocery Code. So as indicated, we will talk about the Food and Grocery Code next time, but this time I want to talk in particular about the Horticulture Code of Conduct. And I think it is important. I was interested in the comments earlier about this sector being characterised by long-standing arrangements between agents or brokers and growers. And I think it's interesting when I reflect on the drama of the dairy industry in 2016, it was similar. A lot of growers and producers in that sector had been supplying a particular dairy processor for a long time. And in fact, most of the agreements between dairy processors and farmers were unwritten. There was no written agreements between them. And so when the real crunch came, when China effectively shut down a lot of the dry milk powder exports, and there was a big drop in prices, a lot of producers were very, very shocked to find out that, in fact, the processors under the arrangements between them could retrospectively reduce the prices they'd paid. And so a lot of the farmers in that sector, on paper anyway, ended up actually owing their processors substantial amounts of money as a consequence of decisions that were made. So what it really highlighted was whilst sometimes it can feel like paperwork, while sometimes it can feel like a lot of process, it is really important, particularly in these industries where there's some of these long-standing arrangements, to make sure both sides of an agreement are familiar with the terms of that agreement. And I think if you take nothing else away from the discussion today, that's effectively what the Horticulture Code does. It sets a requirement to have those agreements in place and some minimum standards for those agreements. It doesn't set the price. It doesn't do a lot of other things, but it really does try and make sure that there's that clear commercial agreement or arrangement between growers and their agents or merchants. So I'll take you through some aspects of it today, and as indicated, hopefully we can have time for questions at the end of it. So the code is a prescribed mandatory code. That means, in effect, it's law under the Competition and Consumer Act. We can take enforcement action under it and impose penalties and court orders for breaches of the code. So it does have force, and it applies, interestingly enough, equally to growers in some respects as it does to merchants. So it's useful for growers to be aware of the obligations they have as well as the rights they have under the code. As I indicated, the aim is to improve the clarity and transparency of the trade arrangements between growers and traders, and it applies to growers and traders, which are either agents or merchants of unprocessed horticulture project. It doesn't come into play where a grower is supplying a manufacturer, for example, a processed fruit or vegetable manufacturer, and it doesn't come into play where a grower is supplying a retailer directly. In that case, that agreement or that arrangement is likely dealt with under the Food and Grocery Code. So there are some limitations to it that are important to understand, and so it won't necessarily automatically apply to all growers. I guess the 7 points on the screen here really summarise the code in a nutshell. It has a requirement that you must have a written contract between yourself and your agent or merchant. It requires your agent or merchant to publish their terms of trade, which are the sort of high-level conditions on which they are prepared to enter into agreements with growers. It applies an obligation on both parties to act in good faith, and that's a concept in relation to commercial arrangements, which basically means you have to behave as much as you can honestly, and not put the other party under duress or engage in unfair practices that might significantly disadvantage them. And it's not always clear exactly what good faith means, but it basically is something that's interpreted by the courts should that come to be. Merchants, and that's where you enter an agreement with an agent or merchant where instead of an agreed price, there is an agreement to sell the produce at best and return the proceeds back to the grower. So in that situation, the HBA is supposed to explain how the prices will be calculated, and often they're just expressed as sale price minus a percentage, maybe 15% or something like that. But that does require a detail in the agreement. Growers and traders are both required to keep certain records. There are penalties for breaching certain sections of the code, which I'll talk about. And it also does provide a process for dispute resolution, although there are alternatives available as well. So that is useful to keep in mind. And as I indicated, it is a code which is mandatory, which means it's part and parcel of the Competition and Consumer Act, and therefore penalties can be applied as a consequence of a breach of the code. So just going through a few bits and pieces. So the horticulture produce agreement, that is the agreement between growers and their merchants or agents, should contain most of the sort of issues that are listed on the screen there. So it should spell out how you have to deliver, who pays for delivery, what their arrangements are in terms of rejection of produce, what are the quality and quantity standards, is it fresh specs or is there a particular standard that the trader applies, whether those proceeds are going to be part of a pooled arrangement or not, what the terms of payment are, who's responsible for bad debts in the event of non-payment, how much commission might be applied in the case where it's an agreement with an agent, and all those sorts of things. Now, you know, it's not entirely specific. These are the things that are required as part of a HPA, and there may well be other parts of it on the way through. So it's not specific exactly how a HPA should be set out, but they're the elements that should be part of it. And that HPA has to be a written agreement between the grower and the trader or merchant, and there has to be some indication of acceptance of that. So in other words, some degree of either a signature or an email indicating that that agreement has been accepted by both parties. Traders have to keep copies of that. They have to keep various notices that they might issue under that, and even if they terminate, they have to keep a record of the notice of termination. Similarly, when it comes to rejections or a statement for a particular period given to a grower. Growers should keep and must keep any HPA they enter into, any written notice or offer they receive from the trader or merchant, and in the case of a termination, they should also keep a copy of that, because that can often be an aspect of a dispute, so quite important. And it is important that growers do keep those records, because, and we see this quite often, where there is a problem where we might be asked to intervene, or a dispute resolution organisation such as the Australian Small Business and ASBFEO, the Australian Business and Family Enterprise Office. The first thing people will be asked for in that situation is the details of the agreement. And if you haven't got something in writing, if it's a verbal agreement or you've lost the notice or whatever, it's very difficult to make progress in terms of resolving that dispute. So while it looks like a lot of paperwork, and while it does seem somewhat bureaucratic, I think it really is important that growers do retain any of that paperwork associated with their arrangements with merchants or traders. As indicated, we recently, we conduct regular compliance with the code. So the way that works is we pick a select number of traders. We obviously can't cover the whole field. We pick a select number of traders based on a number of criteria, and then we have the power to require them to furnish us copies of, for example, their terms of trade, all the HPAs they've entered into, any of the disputes they've been involved in, any of the rejections that they might have carried out, all those sorts of things. So we can require a full set of those agreements, and in that way check the extent to which they're compliant with the code. So we do those on an annual basis sometimes it might be a year or so between them, but we will send out notices to a selection of traders and require them to furnish those for us to have a look at. We did those checks in 2022, and we updated our guidance on the basis of what we saw there. So the two issues we picked up in that compliance check were merchants and traders not always making their terms of trade available clearly for people to look at. So it doesn't mean that the merchant or trader has to have their own website with those terms of trade published on it. They can do it, for example, through an industry website such as the Fresh Produce Association website, but it does mean they have to be published and publicly available. It should be available for growers to look at if they want to. And the second area that we noted some problems with is in merchant agreements where the account sale back to growers simply said, sale of X boxes of apples, Y dollars, and didn't include what the gross price was received for those apples, what deductions or commission or other levies the merchant took out of that, and therefore what the net proceeds were. So we updated our guidance to indicate that the traders in a merchant agreement have to provide growers with the gross price as well as obviously the details leading to the net proceeds. Now, we have engaged in discussions with the Merchants Association about that. Some of them suggested that their software would need upgrading to do that. We've tended to be a little bit flexible in that regard, but we will be revisiting that issue not too far down the track. So if your merchant isn't providing you with the gross price and then a more detailed summation of how they get to net price, then they should be aware that we will be focusing on that in our next little while and paying close attention to that, because it is quite an important piece of information for growers. And it's worth, I think, growers being aware as well as merchants that there is a compliance program associated with the code. So we are on a regular basis checking compliance with the code, and there are penalties associated with that. So we can, where we find non-compliance, we can require a court enforceable undertaking. We can issue an infringement notice, which is like a speeding ticket, except it's typically in the region of $10,000 or more, or we can go to full court action in the case of a major breach. And I think it is important that merchants and traders are aware of that. So just to give you a couple of case studies, Mitolo, which of course is the major potato processor down in South Australia, we received quite a few complaints from growers supplying Mitolo. They had supply contracts that had quite onerous conditions in them, were very uncertain in relation to price, and also very uncertain in relation to rejection and what happened to the product that was rejected. So when we looked at that, we took action. We took that matter to court because we thought this is a major processor and the matter was relatively serious and putting growers at a considerable disadvantage given the nature of their contracts and their inability to supply anyone else. And the federal court agreed with us, and Mitolo faced a penalty of nearly $250,000 because of the way they had their business arrangements and their agreements with growers. So that was quite an important benchmark, if you like, I think, for the whole merchant and processor sector. In this case, Mitolo was both, and therefore covered by the code. and really perhaps sent a warning to them to be quite careful how they went about their business. We also had several other matters where we imposed lesser penalties. For example, Stuart Dixon Produce in 2018 had an infringement notice of 10,500 for trading without having written HPAs in place. And in the case, we had a matter involving Rich Red Fruits, and they had to change some of the terms in their horticultural produce agreements. They weren't fined. And then we had a matter involving Grapeco, and they made they had a number of issues there. One was false and misleading representations about where their grapes had come from, but also they were trading without a horticultural produce agreement and failing to publish and make publicly available their terms of trade. So, I think quite important that people understand, given the mandatory nature of this code, there can be quite serious implications where the code isn't complied with. So look, that's probably given you a bit of a quick rundown, and left a bit of time for questions. We're always interested in comments or concerns that growers might have about how their business arrangements are operating in relation to merchants and traders. So if you ever want to inquire about that or make a report, please don't hesitate to do that. If it's a matter of needing to resolve disputes, then ASBEFIO, the Australian Small Business and Family Enterprise Ombudsman, is the appointed dispute resolution process, or you can agree to a dispute resolution process direct with your merchant. But that ASBEFIO option is available, and it's proving to be quite effective and cost effective in particular. It doesn't seem to impose huge costs on the parties, and quite often it seems they're happy to resolve it through that process and get on with life rather than end up, for example, ending up in court, which can be extremely expensive. So that's given you a bit of a rundown. I know there's a fair bit of detail there, but I'm really happy to take any questions or comments. Thanks, Richard.
Thank you, Mick. That was fantastic. Appreciate that. We do have about 5 minutes remaining for any questions. If there are, please raise a hand. I believe guests can unmute themselves to ask a question. Also welcome to put something into the chat. We have a question from Steve. Please advise, if we are agreed price, why do we need to show the method?
Well, if you've got an agreed price, then yes, the method is the agreed price. So that's very straightforward. But quite often, the method of determining the price, as expressed in those agreements, is sale price less, for example, 15%, and that needs to be spelled out. But if the method is an agreed price on receipt of the produce, that's pretty straightforward. Is that exactly the response? Maybe I misunderstood that.
There's a follow-up from Steve in the chat. Timing of agreed price is challenging. We understand this is at point of sale.
That's what we're talking about. So that's a merchant agreement where the method will be sale price, for example, less 15%. And it's very unclear in that situation when proceeds will be available. Obviously, it's when the merchant manages to sell the produce. And the other aspect of that is if it is sale price minus 15%, then the merchant should tell you what the sale price is when he provides you with an account sale. But that can be the method expressed as sale price minus 15%, etc.
Thanks, Mick. We have not point of delivery was the following question from Steve. Is there a difference between point of sale and point of delivery? I think is the question.
If the price, if the arrangement is agreed price at point of delivery, then on receipt into the warehouse, presumably the ownership of the produce changes, and what the merchant does with it after that is their business, as long as the price is what was agreed. But if the price is sale price, so in other words, the grower still retains ownership of the produce while it's in the merchant's warehouse, and it's only sold, or he only receives or she only receives proceeds for it when that produce is sold, then that's a merchant agreement that is one of the ones that has some issues because of the uncertainty around when the sale might occur and what the gross proceeds were, and therefore, you know, the charges that have been levied on that sale.
We have a thanks from Steve. I think we successfully got to the bottom of that one. Thank you, Mick. Any other comments or questions? No. I'm taking that as a no, which is fantastic, Mick. You've addressed all the issues. It is
probably
quite
not going
complex.
to ask. They think we might come after them.
It is reasonably complex when it comes to the differences between being an agent and a merchant and what that involves. So if you do have any further questions, please feel free to post those through to the agriculture unit. You can see details for that still on your screens. Likewise, if you'd like to raise any issues or concerns you might have with your trading relationship, you're welcome to share those with the ACCC as well. Otherwise, another way through would be with your industry body, whether they're a member of the NFF Horticulture Council or not. You can see, I guess, on the Horticulture Council website, those members of the council. You're welcome to direct those concerns to me at hortcouncil@nff.org.au as well, and I can pass those on to the relevant authorities, whether that is ASBEFIO or the ACCC.
And it's worth making the point that in relation to concerns being expressed, we can retain confidentiality around those, at least in the initial stages of a matter. If it gets serious, yes, then the question may emerge as to that person who's making the complaint may need eventually to be identified. But people should be reassured that certainly in the initial stages of a matter, we can retain complete confidentiality. So if there's fear about retribution, for example, or being cut off or you know, no longer being able to trade, that shouldn't be a concern in terms of that initial inquiry.
Fantastic. We might wrap up there. Thank you everyone for your attendance this afternoon, and thanks again especially to Mick and the ACCC team for sharing those insights. Again, just another plug for the next webinar in this two-part series covering the Food and Grocery Code, Thursday the 9th of March, again at noon Eastern Daylight Savings Time. Thanks everyone, and we'll catch you again soon.